Hi everyone, welcome to Impact Academy. So let us continue with the Indian Polity President. Okay. So we have seen about his election, impeachment, and several other things about the president. Now let us look at the pardoning power of the president. So president as well the governors possess power to grant pardons. Okay, this is very important. 72 Article 72 we have already seen, right? So president is starting at 52. Okay, the president of India is 52, and we have seen 54 election of president and qualifications 58, procedure for impeachment 61, and we have also seen 72. Okay, power of president to grant pardons. Okay, and 161. So governor will governor will start around 163. Okay, like that. Let us see quickly. Okay, so governor is 153. Okay, that is in part 6 states. Chapter 2 executive, 153 is governors of states. Okay, and all these things. So 161 is power of governor to grant pardons and suspend, remit, or commute sentences in certain cases. Okay, so this is very important. Power of governor to grant pardons, and there it is 72. For the president, it is 72. For the governor, it is 161. Both are important. So, pardon rescinds, abrogates, or revokes both the sentence and the conviction and absolve the offender from all punishment and disqualifications. That means if the president pardons, okay, so it is completely both sentence and the conviction, everything is absolved. If it is commutation, commutation means merely substitutes one form of punishment for another form of lighter character. For example, rigorous imprisonment to normal imprisonment, like that. So these particular five things are very important. Frequently questions are asked. So what is remission? Remission is reduces the amount of sentence without changing the character. That means if it is for 10 years, maybe it is reduced to 7 years or 5 years. That is remission. Okay. So commutation is simplifying the punishment. Remission is reducing. Respite means avoiding lesser sentence instead of penalty prescribed in view of pregnancy of a women offender, etc. So especially for pregnant women offenders, you are giving some respite. It means avoiding a lesser sentence. Next, reprieve. Reprieve means stay of execution of a sentence, exam pending a proceeding for pardon or commutation. For example, if there is a death sentence and they have applied for pardon to the president, okay. So before the pardon is granted or dismissed, you cannot execute the sentence. Okay, that is reprieve. So when asked in a form of a question, sometimes these things can be confusing. Okay, so pardon is easy to remember. Pardon means complete pardoning. Okay, so this reprieve and respite, remission, you might get a little bit of confused. Okay, so commuting means from one place to another, right? So instead of one form of punishment, you are giving another form of punishment. That is commute. Remission means reduction. Try to see, we try to reduce the carbon emissions, right, in the environment. So similarly, emission, okay, emission we try to reduce. So try to remember like that. Remission is reduce. Respite is giving some relief. So for pregnant women, etc., giving less sentence. Reprieve is basically stopping the execution of the sentence till the process pending is over. Okay, try to remember these things. Questions are frequently asked. So comparison between pardoning powers of the president and the governor. So this is very important. Frequently, such type of questions are asked. This comparisons. So president has the power to grant pardon, reprieve, respite, suspension, remission, commutation in respect of punishment or sentence by court martial. Governor has no such power. So court martial is basically it relates to the defense. Okay. So the defense personnel do not come under our regular law and order. So they have a separate system. So they are court martial. That's why, like if a soldier even uh, gets into a fight or kills a person, he is not directly put in normal jail. Okay, he is first sent to the military or the defense special courts, and there they get court martialed, etc. So they have a different system. So president has the power with respect to court martials also. but the governor has no such power. Okay, the president powers extend up to the executive power of the union. Governor power extends up to the executive power of the state. So the governor cannot pardon or do all these things to prisoners in some other state. Okay, only within his state. Governor has no power to pardon in case of sentence of death, but he can suspend, remit, commute a sentence of death. Okay, so in the case of death sentence, he cannot completely pardon it, but he can suspend, remit, or commute it. Only president can pardon death sentence. So these are very important points. So when it comes to death sentence, only president. Governor can also deal with death sentence, cannot pardon it completely. Okay, he can only reduce it, and he has only powers within the state and no powers with regarding to defense personnel. Okay. So, if you look at the emergency power, the president has extraordinary powers to deal with a situation of emergency. Okay, governor does not have. So, there is a difference between this thing. So, miscellaneous powers. The president has the constitutional authority to make rules and regulations relating to various matters. Okay, he has the constitutional authority. So, he or she has the power to give instruction to a governor to promulgate an ordinance of a bill containing same provisions requires previous sanction of the president. Okay, if there is a requirement of previous sanction of the president, he has the power to give instruction to the governor also. So, president has the power to refer any question of public importance for the opinion of the Supreme Court, and this comes under Article 143, I believe. Okay, that's also very important. Article 143, power of president to consult Supreme Court, very, very, very important. Okay, so we have seen 142 and all these things, enforcement of decrees, Supreme Court. Okay, so Supreme Court will be establishment of Supreme Court 124. It starts from 124, and we've seen all these things. This 131 is important, original jurisdiction of Supreme Court. Okay, and also we've seen special appeal. Where is that special? Okay, special leave to appeal 136 is also important. Okay, 136 special leave to appeal by Supreme Court is important. 141 law declared by Supreme Court to be binding. Okay, 142, and all these things are part of the basic structure of the constitution. Okay, so president has the power to request for the opinion of the Supreme Court in any matter, and it need not necessarily be binding on the president. President has the power to appoint certain commissions for the purpose of reporting on specific matters, such as commissions to report on administration of scheduled areas, welfare of scheduled tribes and backward classes, finance commission, commission on official language, and interstate council. So all these things are not what is a continuous body. Okay, finance commission, for example, is constituted once in 5 years. So it's the president who appoints. Who appoints these commissions. Okay, the president has some special powers relating to union territories or territories which are directly administered by the union. So some union territories will have legislature like Delhi, okay, Jammu and Kashmir, etc. But other union territories will not have a legislature. So in such a cases, they are ruled directly under the command of the president, okay, with the help of the lieutenant governor, etc. The president shall have certain special powers in respect to the administration of scheduled area and tribes and tribal areas in Assam also. So, with respect to the administration of scheduled areas and scheduled tribes, the president has special powers. Okay, try to remember that. Also, this we have this fourth schedule and fifth schedule, right? So, Assam, Mizoram, Meghalaya, Tripura. Okay, those are especially in the fifth schedule. Okay, that's also very important. The president has certain special powers responsible regarding the administration of the scheduled caste areas. Okay, so if you look at comparative study of the president and governor, okay, when you talk of the election, we've already seen members of electoral college consisting of all the elected members of Lok Sabha, Rajya Sabha, elected members of state legislature, and elected members of the union territories. Basically, all the elected members. So, and this is from Article 52 to 78. We've seen Article 52. Governor is from 153. So, 52, 153. 153 to 167. Governor, Chief Executive Head, Nominal Head of the State. And the 7th Constitutional Amendment Act, 1956, same person as Governor for 2 or more states. So, 7th Constitutional Amendment Act of 1956 is saying that there can be one governor for more than one state. And he is the central nominee but independent constitutional office. Canadian model of appointment of governor. Okay, so qualifications, let us look at qualification. 35 years, and here also 35, so try to remember that both president and governor 35. So he has to be qualified for member of Lok Sabha. So governing belong to other state is the recommendation. Okay, it's not a constitutional provision. So it is recommended with the Sarkar Commission that a governor should be from some other state, so that he does not get too much involved in the local administration. I mean, the administration of the state. Only he is acting the role as an observer. Okay, does not get involved in the politics of the state. So condition: not a member of either house, no office of profit, immune to criminal proceedings, even if personal. Okay, this is very important. Even if it is personal, he is immune from criminal proceedings. And if it is civil proceedings, 2 months notice should be given. 5 years, and resignation should be addressed to vice president, eligible for reappointment to any number of terms. Okay, not a member of either house, should not be a member of either house, no office of profit, immune from criminal proceeding, even if personal, no criminal proceeding during his term. So, as long as he is the president or the governor, there is no chance of criminal proceeding. That means if the governor or the president attacks someone or steals money or usually something, usually they won't do like that. So maybe that's the reason. So criminal proceedings will not be allowed, but civil proceedings. Suppose he did not pay taxes somewhere, or they get into some real estate and something. So the other party says that he has been like that, civil, okay, not criminal. When crime is not involved, only in civil cases, 2 months notice. Okay. Article 158: the emoluments and allowances of the governor shall not be diminished during his term of office. Okay. So if you look at impeachment, there is a proper process initiated by either house, 14 days notice and one-fourth members. We have seen all this, right? It can be initiated in either Lok Sabha or Rajya Sabha. But here, his term is 5 years usually, but subject to the pleasure of president. Okay. And governor has no security of tenure. That's why whenever a new government comes, usually the existing governors are usually asked to go to some other place, or they are asked to resign, or usually these things happen. So there is no proper tenure. There is no this process of impeachment and all. Okay, reappointment in same state is possible. Transfers of governors is by president. Okay. So resolution passed by special majority in both the houses. Okay, resolution should be passed by special majority by both the houses. In the impeachment, elected and nominated member of Lok Sabha and Rajya Sabha participate. So in the election of the president, only elected members of all state legislatures, Lok Sabha, Rajya Sabha, UTs, everyone, where there is an elected member, they all participate in the election of the president. But in his impeachment, only from Lok Sabha, Rajya Sabha they participate, and not just elected, even the nominated members. So this is something which you have to remember clearly. This main difference between election and impeachment is frequently asked. Okay. So from state governments and UTs, they don't have any power to vote in the impeachment of the president. Chief Justice of High Court may be appointed temporarily if the office is vacant. So if the governor office is temporarily vacant, the Chief Justice of the High Court may actually take up that power. So if you look at the powers of president, so executive power of Union of India is vested with president. Here appoints tribal welfare minister, appoints CM, Advocate General, State Election Commissioner. Okay, acts as Chancellor of University. Okay, all the universities, the Chancellor is by default the governor. That's why if you look at any university, the head of the university in that particular area, you see him as Vice Chancellor. You don't see him as Chancellor. Okay, Vice Chancellor of Andhra University, Vice Chancellor of JNT. Okay, so all these things. So basically, the governor is the de facto Chancellor. That's why you have a Vice Chancellor. Okay, legislative. He nominates 12 persons to Rajya Sabha, decides disqualification of members with the Election Commission, issues ordinances, and summons, prorogue, dissolves Lok Sabha, appoints speakers and deputy speakers when office is vacant. Next, here in the case of governor, summon, prorogue, dissolves State Legislative Assembly, nominates 1/6 member in the council. So in the MLC elections, 1/6 of the seats are nominated by the governor, gives assent or withhold assent, written bills, and also reserve bills for consideration of president. He can also issue ordinances. Money bill prior recommendation is, so when it comes to money bill, Article 110, right? Prior recommendation of the president is required. Union budget after president summons constitutes finance commission. So money bills are only with the prior recommendation of governor. Constitutes state finance commission every 5 years. Okay. So in both cases, money bill means it requires prior permission. So judicial point of view, appoints Chief Justice of India, judges of Supreme Court and High Court also. So High Court is not governor. High Court also is president. Seek advice from Supreme Court, grant pardon, commute punishment. He is consulted by the president while appointment of judges of High Court, pardoning power except death sentence. Okay, and in defense cases, he cannot pardon anything. Okay, president has pardon power in defense services also. Veto. President have three alternatives for the bills. One is give assent, withhold, or return. President enjoys three vetoes. No qualified veto, that is overridden by legislature with higher majority. Anyway, so absolute veto. Absolute veto means to withhold his assent and the bill ends. It is available for private members. It is available for private members bill and when cabinet resigns. So the power, the president has the power for of absolute veto. That is, even if it is passed by the Lok Sabha and the Rajya Sabha, the president can still withhold assent, and that is only for private members bill and when cabinet resigns. Not in case of money bills or constitutional amendments. We have already seen that. But for normal bills, president had quite a power. Okay, absolute veto. And suspensive veto, that is when he returns the bill for reconsideration, no suspensive veto available for money bill. So in the case of money bill, he cannot return it, but for normal bill, he can return the bill. That is called a suspensive veto. So pocket veto, simply keeping bill pending for indefinite time. No pocket veto available for constitutional amendment bill. Okay. So Indian pocket veto is wider than American because if the president so wishes, he can just keep it. Okay, keep the bill aside. That is called pocket veto. So it's a very powerful. Many people think president does not really have any power, but if the president or the governor actually want to act, okay, they have a lot of power. But usually, the Supreme Court or the interpretation is such that you have a government which is a representation of the people. So in a democracy, people should have more power. Okay, so usually when a bill is passed in the parliament or the assembly, it usually gets the assent of the president. But if the president wants, he can use any of these vetoes. So he has three absolute veto, suspensive veto, and pocket veto. So president's veto power over state bills. Now, when the according to Article 200, okay, governor has four options: give assent to the bill, withhold assent, return, or reserve for the president. This is one extra. Okay, more than president, because president cannot refer it to anyone. Governor can reserve the bill for the president. So if the bill is reserved for president consideration, he has three options. One is give assent, withhold assent, or direct governor to return the bill. President is not bound to give assent to the bill. Okay, this is one extra power to the president. He can send back the bill again and again. But in the case of what you say, we've seen already constitutional amendment acts and etc. If the bill is sent back to the president with or without amendments, he have to give assent the second time. So here in the governor, uh, so we've seen all this veto power for ordinary laws. Governor has four alternatives: assent, withhold, or return, or reserve the bill for president. Regarding money bills, governor has three alternatives. He cannot return the bill for consideration. Okay, money bills he cannot return for consideration. If money bill is reserved by the governor for president, then president has two options: assent the bill or withhold assent. President cannot return money bill. So if it is a money bill, president cannot return even if it is from the state also. This is one thing to remember. Usually, when a bill, when a state bill comes to the president reserved by the governor, he can send it back. Okay, he can return. But if it is a money bill, he can withhold assent. That is there. He can do pocket veto. He can stall it for indefinite time, but he cannot return the money bill. So ordinance making power is also very important. Here it is 123. Here it is 213. Okay, so easy to remember. 123 is ordinance making power. That is president to promulgate ordinance during recess of parliament. Okay, prolongate only when both Lok Sabha and Rajya Sabha are not in session, or either house is not in session. Only when he is satisfied to take action. Okay, satisfaction is under judicial review according to 44th Amendment. So when Parliament reassembles, both houses must approve the particular ordinance before it becomes an act, and it expires 6 weeks. Maximum life is 6 months, 6 weeks. Okay, that is after coming to power in 6 months, 6 weeks, it has to be approved by the parliament or passed by the parliament. Can issue ordinance only on the advice of council of ministers. Ordinance cannot be issued to amend the constitution. So you cannot amend the constitution through ordinance. Ordinance making power of president is coextensive with parliament but not parallel. That means whatever parliament can do, only on those issues you can do ordinance. Okay. If the parliament also does not have power to do something, just because you have ordinance power, you cannot do that either. Okay. So ordinance is basically a temporary alternative for parliament when the parliament is not in session. So when we look at the governor, Article 213, promulgate ordinance when both or either of the houses not in session. Okay, only when he is satisfied to take action. Can issue ordinance only on advice and council of ministers. So ordinance making power of president is coextensive with parliament but not parallel. Ordinance making of power of governor is not discretionary power. President can instruct governor to ordinance making. So if the president wants, he can instruct the governor to make some ordinances. Pardoning powers of governor. Okay, we've already seen pardon, commute, reprieve, respite, suspend of any against state laws, and no death sentence cannot be pardoned, and no defense. So, but the president has more pardoning powers. He can pardon completely, absolve, commutation, remission, respite, reprieve, stay on the execution of temporary period. Okay, appointment of PM, no majority in Lok Sabha, or when PM dies in office. All these things. Dr. Rajendra Prasad, two times president. Neelam Sanjeeva Reddy, unopposed in 1977. Okay. Zakir Hussain died in office, and VV Giri was the acting president. And establishment of separate development board, Maharashtra, Gujarat, etc., etc. Discretionary reservation of bills for president consideration. Okay, this is completely in the hands of the governor. No need of any council of ministers or anything. He can recommend president's rule. Okay, president's rule is also very very important. Article 350, 352, 356, all those things. Okay, administration of adjoining duty. Okay, so if there is a say Punjab, then administration of Chandigarh, seeking information from chief ministers regarding administrative and legislative policies. So the governor has this power to seek information from chief minister. And governor, recently several questions are being asked on the role of governor in mains and prelims also. Okay, because recently more and more governors are in news. If you look at Telangana, Tamil Nadu, Kerala, okay, everywhere governors are actually not limiting themselves to the ceremonial position. They're actually starting kind of using their powers. Okay, this withholding assent to bill and all these things. So recently governors are more in use. Anyway, so that is about the president. So so let us quickly look at the vice president also. So the vice president is indirectly elected by means of single transferable vote. State legislators do not take part in the election of vice president. Okay, state legislatures do not take part in the election of vice president, but in the case of president, elected members of state legislatures also take part. But for vice president, state legislatures do not take part. The electoral college for vice president consists of members of both houses of parliament. Okay, so members of both houses of parliament. To be elected as vice president of India, he must be 35 years. Okay, for vice president is also 35, governor 35, president 35. Okay, he must not hold office of profit, save that of president, vice president, governor, minister, etc., etc. Qualified for election as a member of Rajya Sabha. So, if you want to be vice president, you have to have qualifications that are eligible for you to become a member of the Rajya Sabha. So that will be also similar to the citizen of India. Okay, not mentally unsound or not dissolved, insolvent, all those things. So, in case of a member of legislature is elected as vice president, he shall be deemed to have vacated his seat in the house to which he belongs. So, once you become the vice president, you are no longer the MLA or MP or anything. It is taken that you have vacated. So, term of the office of vice president is 5 years from the date on which he enters upon his office. So, term is 5 years. Office of vice president may terminate earlier than the fixed term by resignation or removal. So formal impeachment is not required for vice president. So for president, you need a lot of process is there. Impeachment for vice president is not required. Vice President can be removed by a resolution of the Rajya Sabha passed by a majority of its members and agreed to by the Lok Sabha. Article 67. See, it has to be initiated in the Rajya Sabha and it has to be agreed by the Lok Sabha. So, a sitting Vice President is eligible for re-election. Dr. S. Radhakrishnan was elected as the Vice President of India for a second term in 1957. So, no functions are attached to the office of Vice President. Normal function of the Vice President is to act as the ex-official chairman of the Rajya Sabha. So, for the Lok Sabha, we have Speaker. For Rajya Sabha, ex-officio chairman is the Vice President. So, if any vacancy occurs in the office of the President, Vice President acts as the President until a new President is elected and ensures upon his office. So, this is only in the case of resignation, death, etc., not in the expiry. If the President's term of 5 years has expired, then until the new President takes charge, the old President will continue. Vice President will not act. But if the President is on leave or he's resigned or he has expired, only then the Vice President will act as the President. For the first time during the 15-day visit of Dr. Rajendra Prasad to the Soviet Union, the then Vice President S. Radhakrishnan acted as the President owing to the inability of the President to discharge his duties. Okay. So, the power to determine when the President is unable to discharge duties or when he should resume is understood to belong to the President himself. Okay. So, if the offices of both President and the Vice President fall vacant by reason of death, resignation, removal, Chief Justice of India, if he is also not there, the senior most judge of the Supreme Court acts as the President. So, for the first time in 1961, when President Dr. Zakir Hussain died, Vice President Sri V.V. Giri resigned. The Chief Justice Muhammad Hidayatullah acted as the President. So, such a President was already there. Okay, President, not President, President. So, that means it happened in the past. When the Vice President acts as President, he gets the emoluments of the President. Okay, otherwise, he gets the salary of the Chairman of the Rajya Sabha. When the Vice President acts as President, the Deputy Chairman of the Rajya Sabha acts as its Chairman. So, when the President is not there, Vice President has gone to the President's seat, the Deputy Chairman of the Rajya Sabha will act as the Chairman of the Rajya Sabha. Determination of doubts and disputes relating to the election of a President or Vice President is described in Article 71. Okay, Article, so we have seen 52 is President, right? Okay, so 52 is President and the Vice President is 63. So, is which article is saying? Article 71. So, matters related to or connected with election of President or Vice President. So, it's saying determination of doubts and disputes related to the election of a President or Vice President. Okay, fine. So, such disputes are decided by the Supreme Court, whose jurisdiction is exclusive and final. So, Supreme Court is the final authority. No such dispute can be raised on the ground of any vacancy in the Electoral College. So, just because there is some vacancy in the Lok Sabha or Rajya Sabha, you cannot say that the election to President is not valid, etc. So, if the election of the President or the Vice President is declared void by the Supreme Court, acts done by him prior to the date of such decision is not invalidated. Okay, very important. So, you become President, you make some, you give your assent to some bills. Okay, just because your election is what is nullified or voided, the assent given to the bills is not invalidated because the President doesn't really play much role, because if a bill is passed, it is passed through the Lok Sabha, Rajya Sabha, Assembly, etc. So, what is the point in? So, if you remove a President, there is no point in invalidating all the acts done by him, right? So, matters other than the decision of such disputes are regulated by a law made by Parliament. Okay, so if the Supreme Court is not there, other small disputes is as per the law made by the Parliament. So, here also Vice President, second highest office, okay, modeled on American Vice President, not directly elected, and is elected by members of, okay. So, this is one key difference. When we are talking of the President, only elected members of both Lok Sabha, Rajya Sabha, Assembly, UT, everything. Okay, only in impeachment of President, you have only all members of Lok Sabha and Rajya Sabha. Here, in the election of Vice President, you have all members of both houses, including elected and not elected. But state assembly, UT, etc., they are not there. Okay, This one important difference. 35 years, no profit, etc., qualified for RS. Term 5 years can be revoked by resolution of Rajya Sabha. No need of impeachment. Okay. Okay. Passed by special majority and agreed by Lok Sabha. 14 days of notice. Ex officio chairman of Rajya Sabha. Power similar to speaker. Acts as president when vacancy. Okay. For VP 2 terms. So Krishnakant was the first to die in serving office, and Dr. S. Radhakrishna was elected as VP for 2 terms. Okay, so that is about vice president and the president. Okay, thank you.